So in this, our last class on the 11th Amendment, we look at just one case, Alden versus Maine. This is I think, a good case to wrap up our discussion of not only the concept of state sovereign immunity, but also the material that we've more recently been looking at, the 10th Amendment cases on commandeering and Congress's commerce powers. This is a 5-4 opinion, and the dissent in this case is written by Justice Souter, who had also written the dissent in the Seminole Tribe case that we looked at yesterday. But this dissent is perhaps even sharper than the one in Seminole Tribe, and by sharper, I mean sharper-tongued. I think that is born of a real distaste or displeasure for I think what Justice Souter perceives and what all of the dissenters perceive as the cavalier quality of the majority's opinion. And I'll try to explain what I mean by that as we go through it. But this 5-4 opinion, really shows this breakdown in the basic theory that underlies all of the cases that we've looked at in the modern era, going back to the necessary and proper clause when we started looking at Congress's powers. And we'll see a number of those cases cited by the majority in Alden versus Maine. Now, Alden versus Maine follows closely upon the heels of Seminole Tribe, so it's important that you have a good grasp of that before you attempt to approach Alden versus Maine. So the statute that is in the background here is the Fair Labor Standards Act, which we've seen before, one of the New Deal statutes that Roosevelt had enacted in order to try to combat the Great Depression. The Fair Labor Standards Act is the statute that sets the minimum wage. It also had a provision for overtime compensation. And we first encountered this when we were looking at the powers of Congress, in specifically the Commerce Clause power, and we saw the court in 1941 in the Darby case uphold the minimum wage as a valid exercise of the Commerce Clause. This is the case where they explicitly overrule some of the earlier pre-New Deal case law. In particular, they overrule the Hammer versus Dagenhart case, which was one of the child labor cases. And then 1985, we see the court uphold the Fair Labor Standards Act against a 10th Amendment challenge when we had a group of state employees suing for to have the Fair Labor Standards Act enforced. Actually, it was the city of San Antonio that sued to try to have the Fair Labor Standards Act not apply to it. But the court in that case, if you'll recall, that was a very split decision, also a 5-4 decision that involved overturning Justice Rehnquist's opinion in National League of Cities. So we've seen the Fair Labor Standards Act be a source of contention before. So in this case, we know two things. We know that the Fair Labor Standards Act can be enacted by Congress, and we know that it can be applied to state employees. So the states as employers are bound by it, just as any other employer is. So in this case, we have state probation officers who claim that Maine owes them back pay. So we have state employees claiming that Maine has violated the Fair Labor Standards Act, and no one is claiming that Maine is not bound by the terms. Garcia settled that question. Maine is bound by the terms of the Fair Labor Standards Act. But here, the state probation officers claim that Maine owes them money, and so they're suing for damages in federal court. That's their first claim. They sue for damages in federal court. The court then decides Seminole Tribe while their federal court case is pending, and the federal court dismisses their suit after Seminole Tribe, as the federal court must have, because the Fair Labor Standards Act, we know, is an exercise of Congress's Article 1, Section 8 powers. The court in Seminole Tribe said that Congress cannot waive or abrogate states' sovereign immunity when it's exercising one of its Article 1, Section 8 powers. Therefore, this claim for damages against the state can't go forward in federal court after Seminole Tribe. So the plaintiffs in this case then don't give up. Instead, they refile their case. They refile their claim that Maine owes them back wages under the Fair Labor Standards Act in state court. And in state court, Maine asserts sovereign immunity, and the state courts dismiss the case, saying that they have to honor their own state's sovereign immunity. So that's the question that we have here, is can a state, so the way I phrase it here, must a state entertain a suit based on a valid federal statute against its own unconsenting state? Or another way to put it is, can a state get out of paying damages for a valid federal law that it's violating in its own state court? So why is this? So why did the plaintiffs here, the Alden plaintiffs, why did they go back and refile their case in Maine state court? So the 11th Amendment, by its terms, limits the judicial power of the United States. Recall that it limits the judicial power of the United States such that by its text, someone from another state, a citizen of another state, cannot bring a state into federal court as party defendant. But by its terms, limiting the judicial power of the United States, it clearly has nothing to say about the powers of state courts. Right? It's only talking about the judicial power of the United States. It's not talking about the judicial power of Maine or the judicial power of Kentucky or the judicial power of any other state. So one might think that the 11th Amendment has nothing to do with this case. But as the court says early on, page 462, the very first paragraph under Part 1, the court tells us that the 11th Amendment is really not the source of this concept of sovereign immunity. As the court says, the phrase 11th Amendment immunity is convenient shorthand, but something of a misnomer, for the sovereign immunity of the states neither derives from nor is limited by the terms of the 11th Amendment. Instead, the court goes on in that same paragraph to say that immunity from suit is a fundamental aspect of sovereignty which the states enjoyed before the ratification of the Constitution. So the fact that the court is even entertaining this suit raises this question. So then, what's the point of the text of the 11th Amendment if the 11th Amendment has nothing to do with this whole concept of sovereign immunity that the court has been fighting over since the late 70s? And Justice Souter asks this question as well. Rather than any slides on the dissent, I'm just going to raise the points that the dissent makes at the appropriate place when they're responding to the arguments in the majority opinion. So if you go over to page 470, Justice Souter says, in response to that paragraph under Part 1, that the 11th Amendment really isn't what governs the concept of sovereign immunity, Justice Souter says, as a consequence of the court's holding here, Seminole tribes' contorted reliance on the 11th Amendment and its background was presumably unnecessary. The 10th, and we'll talk about the 10th Amendment in just a minute, the 10th would have done the work with an economy that the majority in the Seminole tribe would have welcomed. Indeed, if the court's current reasoning is correct, the 11th Amendment itself was unnecessary. Right? So what Justice Souter is saying in dissent is, if you accept what the majority is saying here, then it's hard to explain why the 11th Amendment was written as it was written. It seems to be quite superfluous. Or it seems to be very poorly written from another perspective, because if it's supposed to be granting this very, very broad, all-encompassing concept of sovereign immunity, it had a funny way of saying it. So how does the court start to analyze this question? Does the concept of sovereign immunity, which we now know doesn't derive from the 11th Amendment, does this concept apply to state courts as well, to allow states not to have to comply with federal law in their own courts? Well, the first thing that the court does is it describes the concept of sovereignty as it applies to states. So what is it that allows us to say that states are sovereign? Or what is it that allows us to apply that term sovereignty to a state? Right? Especially, the importance of that question, I think, really you get from the very early the Marshall Court cases that we read from the early 1800s, where Marshall clearly says that sovereignty lies in the people. So what does it mean for a state to be sovereign? Bottom of page 462, so this is part A, over to the top of page 463. Top of page 463, Justice Kennedy says, the federal system established by our Constitution preserves the sovereign status of the states in two ways. So what are those two ways? Well, one, Justice Kennedy says that the states enjoy their dignity, and more on that in a moment. We'll look at Justice Souter's response to that in just a moment. And second, that the states themselves, as sovereigns, can't be the subject of direct federal regulation. And these would be the holdings from New York and Prince, right? The idea that the Constitution, and this is the reasoning of the 5-member majorities in New York and Prince, the Constitution replaced the Articles of Confederation specifically with regards to who could be the proper subject of Congress's regulation. So the Articles of Confederation, Congress could only regulate the states as entities, and remember, it was difficult to get the states to act or to abide by Congress's legislation, and therefore the solution was to allow Congress to act on people individually. And the majority in both New York and Prince said that therefore the national government traded regulation of the states for regulation of the people. There was a very strong dissent in both of those cases by Justice Stevens that argued that historically that's not correct. The framers wanted Congress to, definitely wanted Congress to be able to regulate people, but they certainly didn't give up on the idea that Congress could also regulate the states. Anyway, that is the majority's second instance of how states are sovereign, is that they can't be subject to federal regulation. Of course, that still makes it difficult to then explain Garcia. Garcia then seems to stand as an exception to these principles that Congress can regulate the states so long as it's regulating the states on general terms, on generally applicable terms, the same terms that regulate private individuals. But we'll see, and we'll see throughout this majority opinion and the dissent that Garcia is still a major point of contention here. All right, so that's what it means then for the states to be sovereign. These are the two examples given. So what about sovereign immunity then? So this first point is that yes, sovereign is a proper word to attach to the states. So where does sovereign immunity come from then? Where does it come? Where does the idea that the sovereign is immune come from? Well, the court tells us in Part B of the opinion that it comes from English political theory. This was, again, born of the idea that we've already discussed, that the king can do no wrong. We'll see Justice Souter also has a response to that idea. Then Part C, 1C on the bottom of page 463 here, the court then looks at its own precedent and it concludes that both of these ideas have been long recognized by Supreme Court case law. So how do we understand this? Well, we understand that actually the very first opinion that the court issued on this subject, the 1793 case of Chisholm versus Georgia, was incorrect. That's the understanding, that's the modern understanding of the case, and the 11th Amendment was a corrective to that decision. And since then, the 11th Amendment has been adopted, the court has looked, according to the majority here, to history and experience and the established order of things rather than adhering to the mere letter of the law or letter of the 11th Amendment. And then we have a citation on page 464 to Hans, and remember Hans fits in with that understanding because Hans applied the 11th Amendment to prohibit a suit by a state's own citizen against it, even though the text of the 11th Amendment talks only about suits by citizens of another state. So if the court's point is that for a very long time the court hasn't paid attention to the text of the 11th Amendment, then that seems to be sound. Of course, their disagreement, the long-standing disagreement, is whether or not that 1890 opinion of Hans was itself correct or not. All right, so we have so we understand that the problem, now we have the background law. So how do we get to applying that background law to the actual facts of this case, to the problem here? So the next part of the opinion, part 2 of the opinion, the court tells us that we need to look at a basic structural argument. And this is the idea contained in that second paragraph under part 2 on page 464, that state sovereign immunity, the court says, inheres in the system of federalism established by the Constitution. And since sovereign immunity is built in to the concept of federalism, then the court says it really is the burden, it really is the problem of the party who would challenge that, the person who would try to disagree with that. So the burden is on the party who would claim that the states were required to surrender their immunity to suit in the constitutional design. Right? And the court says in part 2, only if there is compelling evidence will they prevail. So part 2A1 that we have here on 464, 465, this is the plaintiff's argument. This is Alden's argument that in setting up the federal system, the framers, the intention of the Constitution was to allow suits against states when they violate federal law, or at the very least, there was no prohibition, there was no clear prohibition against this in the design of the Constitution. So what is the argument? Well, the argument is based on the Article 1, Section 8 powers and the Supremacy Clause. Right? So the court quotes the Supremacy Clause. This is the idea that any laws that are passed pursuant to the Constitution are the supreme law of the land. So you can imagine the argument here is actually quite simple. The valid federal laws are supreme to any state law. So the Fair Labor Standards Act is a valid federal law. The court has repeatedly held that. We know the cases, Darby and Garcia. Therefore, this trumps any state law to the contrary. So shouldn't the states here in this case have to be subject to suit on this issue? And the argument is also coupled with the necessary and proper power. Right? You can imagine the argument working like this. So we know that the Fair Labor Standards Act is a valid exercise of the commerce power. Congress can make sure that workers are paid the minimum wage and overtime wages. And so the end then is appropriate, and the means through which Congress wants to enforce this idea would be to subject states to suit who would violate, or subject any employer, including states, to suit who would violate that. And that would seem to be a perfectly reasonable understanding of the Commerce Clause mixed with the Necessary and Proper Clause. But the court says, page 465, nor can we conclude that the specific Article 1 powers delegated to Congress necessarily include, by virtue of the Necessary and Proper Clause or otherwise, the incidental authority to subject the states to private suits as a means of achieving objectives otherwise within the scope of the enumerated powers. Although some of our decisions had endorsed this contention, they have since been overruled. So you can see the court discussing this tension that has been amongst the justices since at least the 70s. And Justice Souter responds to this argument over on page 472. He says, he quotes actually John Marshall, just to point out how so Justice Souter here, page 472, part 2A, the bottom of that page, he's pointing out a quote from McCulloch versus Maryland because he wants to show just how far the current majority he thinks has strayed from the understanding of Marshall, who would have been present at the founding of the Constitution. So he quotes Marshall and McCulloch. He says, "In America, the powers of sovereignty are divided between the government of the Union and those of the states. They are each sovereign with respect to the objects committed to it, and neither sovereign with respect to the objects committed to the other. Hence, the flaw in the court's appeal to federalism. The state of Maine is not sovereign with respect to the national objectives of the Fair Labor Standards Act." Right? So what Justice Souter is saying is, because everyone agrees that the Fair Labor Standards Act is a valid exercise of Congress's Article 1, Section 8 powers, that means that the states retain no sovereignty with respect to the exercise of those powers. So, Souter saying that's clearly what Marshall said, and the majority is trying to create some new rule here, undermining essentially federal supremacy. All right, so the court rejects these arguments made on behalf of the plaintiff, and it says instead what we look to see whether or not the states can be subject to suit in their own courts for violation of federal law. We instead look to, according to the court, Part B of the opinion, history, practice, precedent, and the structure of the Constitution. Notice what's notably absent there is the text of the Constitution. The court has clearly given up on grounding this idea of sovereign immunity in the text of the Constitution. So we have only very short excerpts of, and this is a very, very long case, both the majority and especially the dissent. So we have only brief excerpts of the history and practice part. So what does the court say about history? Did the framers ever discuss the idea of a state being sued in its own courts for violation of federal law? And the court says there is no history. We can't find any framer that said anything about this. And instead of thinking that, well, as Justice Souter suggests, that must mean that this wasn't really a very important issue, the court says that the silence is most instructive at the top of page 466. Why is the silence instructive? For the majority, it's instructive because it was unthinkable to anyone at the time. For the dissent, it's to the extent this silence is instructive, it's simply instructive by the fact that no one was obsessing about state sovereign immunity. What about practice? And by practice, the court means what did the early Congresses do? The Congresses that included people who would have been framers themselves. Right? James Madison was a member of the very first Congress. So what did these Congresses do? And the court says when we look at the bills passed by the early Congresses, we never see a law in which the states would have been subject to suit in their own court, and therefore we can find no evidence that this was sanctioned by the framers. And remember, the burden is on the party claiming that the states were subject to suit, and therefore, since we don't see anything there, this works against the plaintiffs in this case. Okay. So then what about we're skipping over because the book skips to 4, which is on the structure. So how does the structure of the Constitution help answer the question? Well, the court says, so this is part 4 on page 466, the final consideration is the structure of the Constitution, and the court's going to break this up into 2 parts. We look both to 1, the essential principles of federalism, and 2, the special role of the state courts in the constitutional design. So what are the essential principles of federalism? And this goes over to the next 2 pages. So the court starts talking about our federalism. The Constitution grants broad powers to Congress. Our federalism requires that Congress treats the state in a manner consistent with their status as residuary sovereigns and joint participants in the governance of the nation. And what do they quote, or what do they cite? They cite United States versus Lopez, right, where the first time the court since the New Deal had struck down a exercise of the commerce power, and Prince, the exercise of the 10th Amendment to strike down a federal statute. And then they talk about, in the next paragraph, the dignity of the states, right? And how, in order to abide by that dignity of the states, Congress can't thrust by federal fiat the states into court to answer for a federal law. The court says in the bottom paragraph of that page that it's even more offensive to state sovereignty to make a state hear a federal claim in its own courts than it is to drag a state into federal court, where the federal court would apply the federal law. And what is it that the court talks about in terms of the case law analogy? Well, they analogize this to the 10th Amendment cases. So they say, bottom of page 466, a power to press a state's own courts into federal service, to coerce the other branches of the state, furthermore, is the power to turn the state against itself and ultimately to commandeer the entire political machinery of the state against its will at the behest of individuals. So it sounds an awful lot like the court is trying to make this the third line of cases under the 10th Amendment. So remember, we read New York for the proposition that Congress couldn't force states to legislate. They couldn't take over, they couldn't commandeer the state legislature. Prince said Congress couldn't commandeer the sheriffs, the arms of the state executive. And now it sounds like the court here is saying Congress can't commandeer the state courts to enforce federal law. There's a problem with them saying that explicitly, though, that we'll look at in just a moment. How does Justice Souter respond to this argument? If we look over on page 473, so Justice Souter makes a number of claims here. He says, in responding to the first point here about dignity, that, and think back to where the court said this idea of sovereign immunity comes from. It comes from English political theory. Some of this is rehashed from the argument in Seminole Tribe. But Justice Souter is pointing out that this idea of states having sovereignty along the lines that the English king had sovereign immunity is where the majority gets this idea of dignity from. And he quotes Blackstone, who talks about the royal dignity that is necessary to the monarch. And Justice Souter is pointing out how misplaced this borrowing of English common law is. And remember, for Justice Souter, this is common law. This is English common law that, like all other English common law, should be modifiable by statute. But that point about it being common law aside, Justice Souter is pointing out in this first paragraph that it is odd to be borrowing this monarchical concept that most of the framers would have rejected. And if you look at the bottom of page 467, so after the court discusses the idea that this looks similar to the commandeering cases, and then it talks about how we don't want any particular individual to drag the state into court to seek money damages, because the court says this would provide access to the public fisc, and it's in the state's sovereign interest to determine how it spends its money. It can't have a federal court telling it that it owes back pay or back damages. Again, Justice Souter responds to that on page 473, where he says it's equally puzzling to hear the court say that federal power to authorize private suits for money damages would place an unwarranted strain on the state's ability to govern in accordance with the will of their citizens. But the bottom paragraph on page 467, the parallel there to the 10th Amendment cases, the Prince, the New York cases, is this concern about political accountability. And the court thinks that this is a problem that would be present by forcing the states to hear federal law claims against them in their own courts, because there's a blurring of the accountability lines. Then the second structural argument is what the court calls the special role of the state courts in the constitutional design. So what does the court mean here? One case that we have not read that's important for you to appreciate though, and that somewhat undercuts the commandeering argument. The court in this case from 1947, Testa versus Catt, decided that state courts must enforce federal law. Right? So if a plaintiff, so imagine a plaintiff wanting to bring a claim not against a state, but against a private party for violating federal law. The plaintiff can choose a state forum or a federal forum. And if they choose the state forum, the court held in this case, Testa versus Catt, the state must hear the federal law. A state court cannot say our doors are only open to hearing state law claims. The state courts must enforce federal law. So that's a well-recognized principle. So in some sense, then, it's hard to argue. And if you go back and you read the New York case closely, you'll see Justice O'Connor having to respond to this point. Because it seems like Congress if the state courts have to enforce federal law, then it seems not the same thing as saying that state legislatures don't have to do what Congress tells them to do. Right? Because so there does seem to be that disconnect. At least since 1947, state courts have to enforce federal law, whether they like it or not. All right, so there's that point. But then we also know that Congress cannot commandeer state legislatures or executive branches, see New York and Prince. And then, based on yesterday's case, we know that Congress cannot subject states to suit based on Article 1 in federal court. So the court says if you take all of these three principles, these three case-based, precedent-based principles together, the court says unless we hold, as we hold in the majority, that Congress cannot force a state to be a party defendant in its own courts based on federal law, unless we hold that, the court says that an opposite holding would create an anomaly. And what is that anomaly? Well, the court says Congress would have more control over, and the federal government would be more dependent upon state courts. And the court finds that to be an anomaly. And that seems to be right. That conclusion seems to be true, that Congress couldn't force states to legislate, couldn't force state police officers to enforce federal law, but they could force states to enforce federal law even against, they can force state courts to enforce federal law against their own states. And they can force states to be sued in their own states, even though under Seminole Tribe they can't force states to be sued in federal court. So the majority says this would be an odd position to find ourselves in. Right? And the dissent's point is this oddity or this anomaly that the majority is noting exists only because of the court's own case law, what Justice Souter would consider the bad case law, because Justice Souter and all four of these justices in dissent here in Alden were in dissent in Seminole Tribe, they were in dissent in New York, they were in the dissent in Prince. And if you look on page 474, this is where Justice Souter responds largely to those issues. And you can see Justice Souter discussing the case of Garcia. You can see how important that with the majority here still views as this lost fight over the extent of Congress's commerce power in the Garcia case. All right, so the court says we have to hold, we're bound, if we want to make some sort of logic or sense of our cases, we're bound to hold that if Congress can't commandeer arms of the state governments, legislative branches and executive branches, and if Congress can't force states to answer for violations of federal law passed by virtue of Article 1 in federal court, then Congress can't force states to answer for similar legislation in their own courts. Now, the majority says that not all is lost for the enforcement of federal law. States, so this is part 3 of the opinion on page 468. The court says, states and their officers are bound by obligations imposed by the Constitution and by federal statute. We are unwilling to assume that states will refuse to honor the Constitution or obey the binding laws. One wonders, though, so what is exactly the message to Alden and all of these probation officers that are claiming that Maine owes them money? It doesn't seem to do them any good for the court to say we're unwilling to assume that the state will refuse to honor their federal law commitments, because it's Alden's very claim that the state is not honoring its federal law commitments. So what are the saving graces here then? Well, the court says the states can always consent to suit. Now, of course, here Maine did not consent to the suit. That's why the case got kicked out of state court. But states can consent to suit. They can consent to a particular suit. They can consent they could have a blanket waiver of immunity in a state statute. Or another way that a state could consent is by accepting federal funds. Remember, we looked at how the exercise of the spending power of Congress can demand, as a condition for the receipt of federal funds, Congress can demand that a state waive its sovereign immunity if it wants federal money. And then the court says that in the last paragraph on the bottom of page 468, the states have consented, moreover, to some suits pursuant to the plan of the convention or to subsequent constitutional amendments. So this might look like an implicit consent to suit in the sense that the court holds that states gave up their sovereignty with respect to those items covered by the 13th, 14th, and 15th Amendments, and therefore, as we read in yesterday's case, Fitzpatrick versus Bitzer, that Congress can abrogate state sovereign immunity when it acts pursuant to those amendments. Moreover, the court says there are areas to which sovereign immunity doesn't even apply, and those would be to suits against localities and municipalities. And I don't think, we didn't read any cases that hold this, but the court has held that the 11th Amendment does not apply to localities or municipalities, only to state governments, not to local governments. And as we know from looking at the Young cases, that state officers can be sued for prospective injunctive relief. Okay, so we see Alden then as what many thought was the natural extension of Seminole tribe. It's interesting that you get the exact same configuration here. The same justices that decided Seminole tribe decide Alden, and the same justices that dissented in Seminole tribe dissent in Alden. Although there's certainly something to the majority's point that if you decided Alden the other way, it would have been an odd outcome just from a practical perspective, because it would have meant that someone could not sue a state in federal court, but they could sue a state in state court. And people were, at the time, people who disliked people who disliked Seminole tribe were conflicted here, because it would have created a logical inconsistency. Although it appears that the dissent here, though, was committed to trying to prove they were more interested in trying to prove the illogic of the whole line of opinions, all of these federalism opinions. Then they weren't as interested in trying to make sense of the case law that they were handed. Just to show you that this issue has not died, that this is still alive and well, the court's most recent sovereign immunity 5-4 opinion comes just last year in this case called Franchise Tax Board versus Hyatt. In this case, we have a Nevada resident who sued California in Nevada state court for a tort allegedly committed while the California Taxing Authority was auditing him. So we have a Nevada resident who had earned some income in California and therefore was subject to California income taxes. The California Taxing Authority did an audit of this individual, Hyatt, And Hyatt is claiming that while they were conducting this audit, they committed some tort against him. And he's suing in Nevada State Court. He's suing California Nevada State Court. So how does this differ from the cases that we read thus far? Well, the basis for Hyatt's suit is not federal law, it's state law. So California asserted sovereign immunity in the Nevada court. The question was, must Nevada honor that defense? Nevada did not want to honor that defense because Nevada said, in our courts, Nevada waives sovereign immunity on torts like this. And therefore, we refuse to recognize another state's sovereign immunity when they come into Nevada courts because Nevada doesn't recognize sovereign immunity. The court held yes. There had been a previous case that had held that the states could do whatever they wanted to in their own courts with respect to when federal law wasn't at issue. The court overrules that case, and the court says that sovereign immunity in another state's court is integral to the structure of the Constitution. So it's another one of those structural arguments completely unmoored from any text. The dissent, now one might argue, but isn't this then the next logical step from Alden versus Maine, right? If Alden flowed logically from Seminole Tribe, doesn't this case, Hyatt, flow logically from Alden, right? If a state couldn't be sued in its own courts, if the state could claim sovereign immunity in its own courts, then shouldn't another state, a foreign state, be able to claim sovereign immunity in another state's courts? So the court holds yes, that this principle of sovereign immunity is broad enough to apply in state courts for a sister state based on state law. Now, the composition of the court has changed. This is 20 years since Alden versus Maine, but you get some of the same justices are still there, but you get the same 5-4 split here. And the court says, no, this doesn't, the dissent says this doesn't follow logically from Alden. If anything, this is an intrusion into the state court system because rather than, so if Alden was about telling a state that the federal courts, that the federal government couldn't tell the states how to operate their own courts, right? Maine said, we have immunity, don't tell us what to do in Maine courts. That principle is abandoned here, according to the dissent, because now what the court is doing in this Hyatt opinion is telling the state courts what they must do. Right? So the Nevada state courts don't get to do what they want to do in this case. The principle then of sort of hands-off federalism, the dissent says, is violated here because the majority tells Nevada you must honor that defense, even though you wouldn't honor it in your own courts if your own state asserted it. All right, so that's 11th Amendment, sovereign immunity. You can see, hopefully, how closely related this is to the earlier disputes, especially the 10th Amendment disputes. Next week, we're going to turn to the 14th Amendment, Congress's powers under Section 5 of the 14th Amendment. In reading those cases, we are going to return to some of this 11th Amendment sovereign immunity because it comes up in those cases. And we'll look at a new type of power that the court will call remedial power in the 14th Amendment. All right. Please let me know if you have any questions about this material. I know this is probably the most difficult set of material that there is. Although next week's material on the 14th Amendment will be a close challenge.